احنا تأخرنا شوي الساعة 10:10. يعني امبارح بالمجمل يعني أنا رأيي كان مهم جدا لفهم موضوع المؤتمر بشكل عام، الإعلان العالمي لحقوق الإنسان، تاريخ صياغة الإعلان، الفاعلين وراء الإعلان، خلفياتهم في بعض الأحيان الفاشية اللي بتدل على المفاهيم اللي كانت موجودة في هذاك الزمان ولا اليوم. وكان في صراع ممكن انه حول هل للاعلان نفسه عده وجوه، ممكن للاعلان وجه اسود او وجه قبيح، البعض يعتقد ان للاعلان نفسه وجه ابيض، لكن كان توجد ادوات مختلفه تستخدمها المؤسسات الدوليه ربما للهيمنه والسيطره من خلال للسيطره على شعوب من خلال هذا الاعلان، لكن توجد ادوات اخرى وسمعنا عن عده ادوات ممكن استخدامها للتمرد على منظومة الهيمنة والسيطرة العالمية. موضوع جلسة اليوم، هل الحكم على حقوق الإنسان بالثنائيات؟ ربما الثنائيات تعني هنا إقصاء الإنسان. عندنا عدد من المداخلات، 4 مداخلات. المداخلة الأولى
be done by Dr. Marina Rosa, who will talk about the margin of appreciation doctrine recreating colonial patterns towards migrants, the evolution of the ECHR's decisions. Dr. Marina is a faculty member at the School of International Relations and at the College of Law and coordinator of the Migrant Clinic of the Ritter dos Reis University Center in Brazil. Please start.
معك حوالي 20 دقيقة. Okay.
Thank you. Bom dia, good morning everyone. My name is Marina, I'm from Brazil. Well, I thank you to Brazil and Muwatin to organize the important conference. Well, this paper is inspired not from the international law of the international relations, but for the Gabriel Garcia Marquez when we questions in the 100 años de soledad why it's the negligence to use the Latin Americans to think of just social justice with the same originality that allowed in literature. However, the theoretical fundament of these study is the decolonial perspective and the the third-world approach to international law. Well, international law was understood a priori as mechanism for maintaining colonial tradition. The internationalist commitment is born thus aimed at legitimizing the colonial expansion, the state sovereignty, and the subjection and domination of the other people, the origin peoples in America. In this sense, international law is instituted to guarantee the European ultramarine domination because of the unique and necessary juridical language to establish relations between Europe and America. That is, international law fills a juridical language gap which permitted the subjugation and domination of the people what would be colonized. According to this order of the ideas, Francisco de Vitoria is the precursor of international law when he proposed the juridical harmonization. Under this consideration, international law uses the ruling language of human rights beings to justify the conquer of the new territories and expropriation to build a juridic mark to settle the European jurisdiction of America. International law is restrained in the first moment to the dissemination of liberal and individual values to the domination of economic rationality of the different things and being. There was no intention to reverse the colonial power structure neither the hierarchical human beings discourse nor the difference between North and South. These assumptions are resurfacing by the advent of the Peace of Westphalia. The conclusion is not of the insufficiency of the Westphalian model put in check the capability of the international law to regulate the relations between states. From out is observed a change of position for the internationalists when we started to recognize the individual as an international law subject, while the human rights brought to via of international sign. For what form part of the international law doctrine, the Universal Declaration constitutes the legacy over which are expressed the universal and indivisibility of human rights. The Declaration follows the French model. This is a hegemonic fundament of human rights, which base is not which her basis is found at Illuminism and attaches the consensus of rights to individuals' rationality adjusted to the colonial patterns. The maintenance of the colonial universal intended text would provide the continuation of prejudicial and excluding practice, making possible to suggest the human rights are universal from the perspective of the modern culture, but are not universal for ones looking for the outside. This condition would contribute to the settling of European universalism, forming the patterns already ambition as universal global values, which among them would be human rights speech. That is, it's not about talking from the declaration its relevance to the institutions of human rights, such as ICCPR. If not the clarify the interesting in international law because it's colonial and imperialist past and present to recognize that the modern international law selectiveness has roots in European heritage already universal. Under this background, emerged different judicial authorities of permanent characters in the supranational plan, aiming the concretization of the international justice, like the European system of human rights. But it should be noted that it is experienced in the Universal Declaration. Additionally, the creation of European system always inserted in the big European cooperation contest to consolidate during the Cold War, strengthen their economies, and above, establish a counterpoint to the Soviet regime, preaching that human rights and democracy are assured at and by Occident capitalists. The European Convention constitutes in regression of compared the Universal Declaration, because only 10 years after the institution of the Convention is when the European system recognized economical, social, and cultural rights, and only in 40 years after recognized the right to equality and non-discrimination. It is not refuted that the system innovating institutes independent legal organism in the international plan to judge violations of human rights in Europe, like the European Court of Human Rights. The European Court has been contribution to the protection of human rights in Europe later because of recognition of its procedure capability to the individuals or the vast firm jurisprudence. However, the acting of the court has been limited of the margin in the application of the margin of appreciation doctrine, which gives to the states a maneuver space to exercise its functions, what allows that they take actions to interpretation and protection the consecrate, which allows them to adopt the measure deemed appropriate to interpretation and to protection the rights enshrinement in the European Convention, since there would be in a better position to define the content and limits of those rights. That is, in name of the national security, the Court of Human Rights and the European states converted the right to migrate and to state prerogative, reaffirming the colonial charter of the international law, because in the name of sovereignty, the European state expel refugees, in the majority the citizens from the ex-European colonials, violating the principle of the non-refoulement, relative rights, etc. But When we compare it to the Inter-American Court of Human Rights, we observe that in this court, the non-refoulement is a jus cogens principle, as defined in the advisory opinion about the work migrants and in the case of family Pacheco Tineo versus Bolivia. But in Europe, that is not admitted. For example, in the Delaya versus France, a Roman citizen whose name had been listed on the Direction Générale de la Sécurité Stratégique by France, and he was unable to conduct his business or provide or receive service in any of the Schengen area states. In the Sala versus Netherlands, the court permit, according to the margin of appreciation, the expulsion of refugees would face a real risk that economic, socio-economical, and humanitarian conditions in the states to return the Somalia. Also, the court in N versus the UK concerning the removal of an HIV-positive applicant to Uganda, where her lifespan has likely to be reduced because of the treatment facilities that were inferior to those available in United Kingdom. But in the South and Elmi versus United Kingdom, the European Court finally had that the indiscrimination violation in Somalia was of sufficient level and intensity to pose a risk to life of person of any civilian there. That situation of general violence in Mogadishu was sufficiently intense to enable the European Court to conclude that any return would be at a risk of ill treatment contrary to Article 3, solely on account of his or her presence in the country. Well, my argument essentially is until and South and Elmi versus United Kingdom, the European states certainly has the power to decide who can enter and state order in their territory, but this decision is the start to alteration the colonial position of the European Court of Human Rights to guarantee authority and emancipation for the migrants. Is that their human rights prevail before the security and state sovereignty. Start because that criteria may be still along the manipulation of the language of the human rights by the European states. Thank you very much.
Thank you, Marina, for covering this subject. Thank you for covering this subject. It is for sure that there is misuse of human rights to control. So we will now move to the second lecture, Engendering Constitutions as a Way to Protect Women's Rights. Sana Asarghali will speak. She is from An-Najah University. She is a faculty member of An-Najah National University. Yes, good morning. Yes, good morning. It could be that the subject that I will talk about today is over-discussed. However, when we talk today about gender-sensitive constitutions, we see that there is an importance to speak about all the rights of all segments of society. However, today we will focus more on gender. We will talk about gender-sensitive constitutions. We will also ask why it is so important to talk about it and how to implement such a constitution. When we talk about this subject, one of the main things that we remember is something that happened in 2010 with Ruth Ginsburg in the Supreme Court of the United States of America. She had a debate with Sandra O'Connor, who was the first female judge who was appointed in 1981. Ginsburg asked, why not have 9 women in the Supreme Court? And the audience started laughing then. That question was bigger than that. the question is, why is there always 9 men judges, and they bring 1 or 2 female judges? Why is it considered that women? Why do they always marginalize women and just add them for the sake of adding 1 or 2 women on a side? That is, as if irrelevant. Unfortunately, despite what some people say, we still see this happening. Even in the Palestinian Constitutional Court, there is a very, very limited number of women, and it seems like they look at women as if they're not good enough. So this constitution does not just talk about women's rights, but it talks about justice between genders. So this is a constitution that should give equal opportunities regardless of one's gender. Therefore, when we talk about the importance of such a constitution, we are first of all talking only about the basics, and also the presence of a gender-sensitive constitution means that we are having a democratic constitution that includes all parties. Today, almost every constitution starts with "the constitution is ours," or "we the people." Therefore, this means that there should be an effective participation and engagement. For example, in Tunisia, they included women, disabled persons, and many other segments of the society. That's why when we write the constitution and we say "we the people," we must include all segments of the people. Therefore, we must always aim to, for example, in Palestine, we aim to receive recognition from the world. However, if we become gender sensitive, then that would mean that we are becoming part of the world more and more, engaging, for example, CEDAW and all the discussions. Gender sensitive constitution is very important, because how can one join CEDAW, Convention for the Elimination of Discrimination Against Women? So we must reformulate our constitutions in different countries in order to become more gender sensitive. And many times negative things lead to gender violations. For example, if the legal text or stipulation does not mention women or the equal rights of women, that would in a way support the violations against women. Another thing is that when we talk about gender sensitive constitutions, we usually talk about countries during conflict and after conflict, in which lots of gender issues occur. In Palestine, we have a kind of transition towards democracy and statehood together, and this is a very difficult thing, by the way. And in order to ensure that this binary transition would take place, there should be a full representation of all segments of the people. We see sometimes some informal speeches taking place. For example, in Belfast, women played a very prominent role in uniting between Protestants and Catholics, but when the official negotiations took place, they totally excluded women, even though the women were the ones who were behind unifying or having a treaty between Catholics and Protestants in Belfast. So there is the marginalization of women, in other words. Today, if we look at the Palestinian Basic Law and even the draft constitution of 2016, do you know about the low rates of female representation? You will be surprised. These were all hidden doors, and there was no sufficient female representation. Therefore, in order to overcome such a thing, we should use certain mechanisms to overcome. In order to avoid prolonging my time, specified time period, I have something here to present to you. It seems like Okay, yeah. Why include the gender sensitive? I will show you something here. The language of Constitution. The language of the Constitution. Many people do not know about that language. Some people misunderstand that. But the Constitution drafting is very important. I'll give you an example. I don't know if you remember the story of an Egyptian citizen, lady that is, who wanted to get citizenship for her children. They told her, how can you get citizenship for your children if you're not married to an Egyptian man? So it seems like citizenship was as if a male-dominated thing. Therefore, the constitutions have tackled this. For example, the Reed versus Reed case in the United States tackled this. Two people were married, and one of them wanted to be in charge of the property. So they explained that the law, they kind of claimed that the man should be the owner and not the woman after they got divorced. But the court tackled this correctly by saying, how can you abuse the legal stipulation and provision? Therefore, for example, in Tunisia, we see the law saying Tunisian men and women, and not just Tunisian men or just Tunisian in the middle implicitly. So even in the Quran, it says the believing women and men, or men and women. So al-mu'minin wal-mu'minat, which means believers who are men and women. So even the Quran took this into consideration, males and females. So it is very important to write the constitutions in the best way. For example, in our Palestinian context, we see that the PLO is the sole representative of the Palestinian people, and the PA is in charge of the constitution. We sometimes disregard this or don't see this. Therefore, we should see more of Muwatin wa Muwatinat, which means male and female citizens. The law must always be gender sensitive. For example, South Africa, when they wrote their constitution, they said male or female president. That was just a reminder for the law, because if a female person runs for elections, people shouldn't be surprised. They need to know very well from the law that gender sensitivity is always there. Therefore, these gender sensitive constitutions are very important. So, for example, if we see the 2015 report of the UN, it seems like their next report will be in 2018 or 2019. In the UN report of 2016 or 15, we see, they mention the importance of women's participation. It seems that in the majority of times they assign women in non-key positions. 15% of the heads of courts in the world are women. This is a very low number, only 15% of court judges. So therefore, the making of the constitution also needs practice on the ground. Unfortunately, in the vast majority of Arab countries, unlike Tunisia, which was playing a leading role in 2014 in theory, but where is the practice? It seems like they only write beautiful things, like after As-Sipsi in 2016, in Tunisia who said that Tunisian women can marry anyone they want, even from a different religion. The Tunisian people started countering that or standing up against that. So it's very important to implement things on the ground, not just keep saying beautiful things, but also to implement that on the ground. Therefore, I don't want to prolong because Mrs. Reem Butman will talk about Sharia courts. So why not have the freedom to choose to marry whoever they want? So in practice, another thing, shouldn't the constitutions, like the hashtag equal payment thing, shouldn't the constitution support the equal payment of men and women? So shouldn't the constitution specify? So the making of constitutions and the practice of that, it's not only the issue of the equal payment, but it seems that the equal payment for work of the same value, this is the main concept. So the work that is done with the same value by men and women should have equal payment. For example, if a man and a woman are running a house, men and women should have an equal share in the things. In Kenya's constitution, we see that they introduced many female parliamentarians. However, unfortunately, during the Kenyan elections, the people did not elect women, but at least the Kenyan constitution supported the presence of an equal representation by women. So as I said, it's very important to implement things on the ground. When we talk about practice, we don't only talk about women's rights, but we also mean all segments of the society. That is, the first implementation is the right of people to the courts, to reach or access courts. For example, in Palestine, individuals have the right to resort to courts, but this is not really activated, has not been really activated. For example, if I get harassed in my work and one of my constitutional rights is abused or violated, where should I resort to? Shouldn't I resort to the constitutional courts? Therefore, there should be the activation of the direct resorting to the courts. Another thing is something we talked about yesterday, the state of emergency and the states of exception. Legal exceptions have led to many violations and abuse of people's rights. The state of emergency is highly problematic. That's why the states of emergency must be specifically defined in order to avoid that violation of human rights. And we see that under states of emergency there is the restriction and violation of human rights. Another important thing for implementation that we must focus on is the independence of the judiciary. Some people might say this is not the time to talk about this, but no, it is very important. When I talk about all of these, I talk about them theoretically, but a constitutional drafting committee must come and write that and must make sure to implement that by other parties. So when we talk about a new orientation for Palestine, I think that before drafting the gender-sensitive constitution, we must start by fixing the mechanisms of the judiciary and the people's freedom to resort to courts, and to get rid of the legislative vacuum that we're living in Palestine. And that's because when I write a constitution, I must have a budget for the legislations. For example, when the law comes and says, so let's put it this way, the law has several problems. I'm not talking about religion, I'm talking about the whole law, modern law. In the vast majority of Arab countries, we see a confusion. So they do not understand the civil aspects of the state. Great confusion is in Arab countries in even understanding the constitution. The constitution seems to be not fair or unfair to many segments of the society. I think that I have covered my part. So thanks so much and God bless.
Thank you, Sana. It seems that even in drafting, when there is a text which is applicable or not, we should ponder more. I mean, it is only for self-interest that we live. There are, consequences and relative points. The third intervention is Mr. Rafael, who is a professor in the London University College dealing with international, and he will speak what is beyond the drafting of history, beyond the state sovereignty paradigm between different active elements while exercising authority in certain situations. So the floor is yours, Mr.
Shukran. It's a great privilege to be back here in Palestine and at Birzeit. I'm very grateful indeed to Mudar for including me in this event, which I'm learning at which I'm learning a great deal. I also want to pay tribute to Joyce for such supremely efficient and comprehensive organizational assistance and generous, warm hospitality, and to the wonderful translators who have done such an outstandingly accurate work and assistance here, and also to the very helpful and welcoming student volunteers. Thank you very much. Now, on Monday, a group of us attending the earlier conference were taken to meet with the community of Khan al-Ammar. At that meeting, the community leader, Amran Rashak, said, and I'm paraphrasing, "People often think that what we want is to improve the humanitarian situation here, for example, proper access to water. No, what we want is to be able to return to the place from where we were displaced." When I heard this, I took it to mean that, whereas of course he was concerned about humanitarian conditions and improving them, he was more concerned about the situation itself, the denial of his right and that of his community to return to the place from which they were displaced. He didn't want the Israeli colonial project to be made more humane. He wanted it to end. Now, the Universal Declaration of Human Rights was, of course, adopted as part of the broader post-1945 lawmaking efforts on humanitarian issues, which included, a year later, the 1949 Geneva Conventions. And those conventions, of course, include key rules on occupation law, supplementing the Hague regulations in a move more generally in this field of law, commonly described as a shift from the state-centric bombs and bullets law of armed conflict paradigm to a human-centered, humanizing approach. Hence the shift in the name being given to this area of law, International Humanitarian Law, IHL. This claim of humanitarianism, embedded in the very name given to the law, is then associated with occupation law in particular. So the ICRC legal department, for example, asserts, and I quote, "The law of occupation is primarily motivated by humanitarian conditions." Now, I'm told that a predominant, if not exclusive, focus on IHL can often be seen when legal questions and advocacy strategies relating to Palestine are discussed. In particular, I'm told there's such a focus, especially on the part of internationals here, whether foreign states, international organizations, or NGOs. For example, the Swedish NGO Diakonia, which in its general work claims to be concerned with ending, and I quote, poverty and oppression, when it comes to Palestine, has a focus described as being on Israel and Palestine, open brackets OPT, i.e. only about the occupation, and within this through an exclusive IHL lens via its IHL Resource Center. Now, as Hassan Jabareen pointed out at the previous conference, an exclusive focus on the occupation and IHL, when this is understood as synonymous with occupation law, or IHL insofar as it applies to the occupation, excludes crucial elements of the struggle: the Nakba, the position of Palestinians in the land of Palestine beyond the West Bank and Gaza, and the refugees. Thus, the exclusive occupation and IHL focus frames the struggle in a way that doesn't even acknowledge the existence of these aspects of the struggle. What is claimed to be a humanitarian effort to vindicate the needs of Palestinians in the West Bank and Gaza is also a means of erasing the struggle as it relates to all other Palestinians, both on the other side of the Green Line and beyond, and also the Palestinians here and in Gaza, as far as their own links, including of land and property, on the other side of the Green Line are concerned. So put differently, the exclusive focus on the occupation IHL framework denies the right of return, the right of Palestinians on the other side of the Green Line to equal treatment, and more fundamentally, the very notion of the Green Line as necessarily an organizing principle for the question of the status of the land of Palestine. In my presentation at the other conference, I argued that also, even within the distorted focus exclusively on the occupation, the exclusive IHL occupation law approach is of necessity, because of the limitations of this area of law, only concerned with the humanitarian conditions of the occupation. The occupation itself is not placed into question. So much then for IHL. As I mentioned, the humanitarian paradigm shift in the laws of war with the Geneva Conventions can be seen as part of the broader foundation of modern international human rights law with the adoption of the Universal Declaration. And that declaration was, as has been mentioned, part of the so-called International Bill of Rights, including the two main global human rights covenants, followed by an array of instruments dealing with the rights of particular groups, different types of rights, etc. Palestine's decision to accede to most of these human rights treaties 4 years ago has of course been part of a strategy, alongside ratification of the Rome Statute and instruments like the Diplomatic Relations Convention, to enable recourse to the international mechanisms of enforcement associated with these treaties, such as the International Criminal Court, and with the very recent case brought against the US regarding the Jerusalem Embassy to the International Court of Justice. In the case of human rights treaties, this has enabled Palestine to bring a case against Israel before the Committee on the Elimination of Racial Discrimination. Now, apart from the Rome Statute and the ICC, what these treaties and their enforcement mechanisms have in common is that they are state-centric as far as the obligation bearers involved are concerned. To use them to complain about Israel, then, as in the racial discrimination case, is, unlike the referral to the ICC, to affirm and accept Israel's statehood. This, then, potentially has implications for the position of Israel as it's currently constituted, both in terms of its territory, its identity as a Jewish state, its population, and the rights of people, including Palestinians, under what is being accepted by this process to be its territorial jurisdiction, and the question of the right of refugees to return to the land covered by this territorial jurisdiction. These are, of course, broader issues relating to the recognition of Israel in general. My point is that they are also implicated in the use of international human rights law as a tool of resistance against Israel. This use also has a particular impact on the dialectic between Palestine's position on Israel's statehood and Israel's position on Palestine's statehood. Off the bat, in triggering any given mechanism, as in the complaint to the Racial Discrimination Committee, Palestine is assuming and affirming Israeli statehood. But Palestine can't activate the mechanism unless it is in turn a state in international law, something which Israel disputes. Indeed, I understand that Israel is planning to put the denial of Palestinian statehood at the heart of its objections to the jurisdiction of the Racial Discrimination Committee in that complaint. This will therefore require Palestine, unlike Israel, to have to prove its very existential legitimacy in order for the case to go ahead. The question of Palestinian statehood will be determined by the procedure in a humiliatingly unequal dialectic. Palestine must affirm Israel's statehood, but has to prove its own. Israel gains a further affirmation of its statehood and an opportunity to further delegitimize Palestine. So what is supposed to be a mechanism to determine individual rights also requires a further deepening of the process of Palestinian recognition of the State of Israel, while at the same time having to go through a formal process whereby its own existential legitimacy is subjected to a sustained trolling exercise by Israel. Of course, the very state whose actions are largely responsible for the conditions that place the practical viability of the State of Palestine, and so its conformity to the international law test for statehood, into question. All the more humiliating because this necessarily operates in tandem with the requirement that Palestine reaffirm its recognition of Israel. If the outcome of this process is that the Racial Discrimination Committee concludes that Palestine is a state for the purposes of the Convention, and so its jurisdiction, that might be seen as a positive achievement in vindicating Palestinian statehood more generally. But it still involves a process that treats the issue as one to be determined by weighing up the arguments of Palestine and Israel on the question of Palestinian statehood, as if Israel has and should have a particular entitlement to a determinative view on the matter, and one which, moreover, should be treated as equal to that of Palestine. So a state that has no legitimate entitlement to play a role in determining Palestine's claim of statehood, and of course through its actions is undermining the validity of that claim, is given an equal voice to Palestine when the claim is being assessed. And through all of this, the Palestinian struggle is being pushed further into the box of an approach based on statehood, both for Palestine and Israel, with all the broader implications this has. The international human rights law system, then, while ostensibly simply being concerned with protecting individual rights, actually also requires the Palestinian people to frame their struggle through the paradigm of statehood for both themselves and their colonizers. Now, assuming that the Racial Discrimination Committee affirms Palestine's claim to statehood and then looks at the complaint, it will only be able to do so as far as those aspects of the complaint that relate to the situation in the West Bank and Gaza, if the committee concludes that the convention applies to Israel extraterritorially. The question of the extraterritorial application of human rights law brings to the foreground the fact that for most of the 70-year period of the Universal Declaration, international human rights law was understood to apply only territorially. During this period, the position that the West Bank and Gaza are not Israeli territory, had the effect of excluding the operation of Israel's international human rights obligations to it in relation to the occupation. And if Palestinians had wished to invoke these obligations in relation to Jerusalem in particular, they would have had to accept Israel's claim to sovereignty there. Thus, the international law position mirrored that in the supposed protections offered by domestic Israeli law, where similarly Palestinians must utilize a legal system that has been purportedly extended to Jerusalem on the basis of Israel's claim to sovereignty there. The operation of the legal human rights protections, then, are of necessity tied to Israel's sovereignty claim. To invoke them is to implicitly affirm the validity of that claim, since they wouldn't be operable were Israel's claim to be without legal effect. Given that Israel's assertion of sovereignty and its application of domestic law to Jerusalem is supposed to be illegal as a matter of international law, the exclusively territorial conception of international human rights obligations required Palestinians in Jerusalem to either forego modalities to invoke their rights or to accept the annexation of Jerusalem. The exclusively territorial conception of international human rights obligations also, at a stroke, excised the issue of the refugees and their right to return from the purview of these obligations. Yesterday, Raif Zereik raised the problem with self-determination as creating, and I quote, a right to close your borders. And there he is at the door, maybe just coming in just as I mentioned his name. When we're focusing on the exclusively territorial conception of human rights obligations mapped onto the Israeli state, it's perhaps better to see this not so much as the right to close borders, as the right to exercise complete discretion about who to let in. This enables Israel to simultaneously close its borders to Palestinians and to open them to Jews, thereby denying the right to return and enabling the further demographic transformation in a Jewish direction, which of course is a mutually reinforcing process when the land and property of Palestinians displaced in 1948 ends up in various ways being deployed for the benefit of Jews migrating to Israel in the period since then. Again, this is linked to the consequences of statehood, given how the silences of international law on most questions of immigration admission by states enable entities treated as states by international law, like Israel, to conceive themselves as bounded demographic communities as they see fit. Of course, the very day after the Universal Declaration was passed, the UN General Assembly adopted Resolution 194, which affirmed the right of return. The exclusively territorial conception of international human rights obligations that predominated for much of the 70-year period since then removed the implementation of this right from the purview of international human rights law. International law, then, offered the promise of human rights, combined the very next day with the affirmation of the right to return, only then to close off a focus on the latter from the purview of the former. Relatively recently, however, it's become accepted that international human rights law applies extraterritorially as well as territorially. So now, as was not the case before, international human rights law can be invoked against Israel without making any assumption about Israel's claim to sovereignty over the place in question. And indeed, one of the seminal articulations of this position is by the International Court of Justice in the Wall Advisory Opinion. This is undoubtedly an important shift. International human rights law now diverges from the position in domestic Israeli law, and it's commonly viewed as a progressive development in human rights law generally, and potentially of great significance to Palestinian rights in particular. However, then this is where I will draw my remarks to a close, but there's so much more to say here. The conventional view of the extraterritorial application of international human rights law is that it only operates if effective territorial control is exercised in a similar fashion to occupation law. So it only addresses a subset of determinative extraterritorial power dynamics operating as a matter of fact. Because of this threshold requirement, states can calibrate their extraterritorial projection of power in a manner that enables them to make a plausible argument that it falls short of the test and is therefore not covered. Palestinian refugees outside Gaza and the West Bank don't fall within any conception of this effective control test, so as to bring them within the scope of Israel's extraterritorial human rights obligations. So then, what is billed as a progressive shift makes no difference to the exclusively territorial conception of human rights law, as far as the right of return is concerned, for refugees outside Gaza and the West Bank. This is then a distorted frame of reference, not of the situation in 1948, when the Universal Declaration was adopted, but only after 1967. And indeed, it's notable that all the modern international human rights treaties only entered into force in the 1967 period. And in the West Bank and Gaza, just as with the test for occupation law, the threshold requirement of applicability leads to ridiculous debates about whether, for example, Gaza is somehow subject to the necessary level of domination and oppression by Israel to warrant the operation of Israel's human rights obligations, as if this is not tragically and horrifically clear for all to see. In the case of occupation law, the effective control test enables Israel to argue that somehow this is a boots-on-the-ground test, which therefore is inapplicable to the control it exercises by sea, air, and at the borders with respect to Gaza. Although Israel continues to maintain the position that international human rights law doesn't apply extraterritorially at all, the similarity of the tests in both areas of law enable the same sort of argument of failing to meet the applicability test to be made in relation to Gaza. That it's even possible to make this argument illustrates, and this is where I will end, one of the paradoxes of human rights law, that people subject to colonial domination must, in order to access an international system that somehow claims to address this, they must first of all convince that system that the domination they're suffering is deserving of the attention of that system, in the face of arguments put by the very actor responsible for that domination that they are not. It is for the international system, not the Palestinian people, to decide how Palestinian oppression and colonial domination is both to be characterized and whether or not it's worthy of critical scrutiny, and according to a test that is only anyway intended to cover a narrow subset of extraterritorial power dynamics. So to conclude then, I would simply echo what Samira said yesterday, that we can see, I hope in what I've illustrated, how, using Samira's words, the project of human rights law has reconfigured the horizons of political and ethical possibilities, diminishing the pursuit of collective freedom adequate for a non-colonial future. Thank you.
Thank you.
Ralph. In the discussion, there will be several questions. Thank you. We will have, but then the next panelist is Reem Butme, who is a researcher in law in Birzeit University, and she is concerned in law and society and social and legal studies about religious courts and what she calls the advance of procedural legal thing, especially in religious courts, and we see it in different aspects. So you have 20 minutes, please. I want to work on religious courts, but I want to disappoint Sana. I want to address to what degree these religious courts fit or do not fit with the accords, and to what degree it is achieving human rights. And this will not be part of my discussion. I'm looking at religious courts as a scene of an existing conflict that was historic. It is not contemporary. It has different frameworks. And speaking about the contemporary state and this APLAC, it has its ethical and political and social dimensions. And another concept that in Islamic precedents and religious courts have been formed, it is not the same that was existing before the reform during the Ottoman period, the Tanzimat that is, and it entered within the modern state paradigms. It does not diminish its authority, as some prominent writers have said, but it has to do with the concepts. In my intervention, I deal with the basic premises that deal with the women rights and international, and to extend the human rights to the margin that the religious courts engage in. This margin has its own traditions, precedents. It has to do with Islamic norms. It has been altered, although it was never cut, and it was connected with specific traits that it introduces itself, that it belongs to such traditions. So you have religious judges who are not necessarily jurists, but people who study the Islamic Sharia. Within this framework and in the contemporary developments emanating from the establishment of the PA and reorganizing the concept of state formation within the Palestinian, there is a new format of religious courts. A basic component is the inclusion of human rights, international law, human rights. So including this, giving it a wider focus, it seeks to impose and to gain bigger space within this space, which is within the civil system of the modern state and its concepts. Whether this system has to do with specific concepts and procedures and to have a definition of the judge and related to the court, whether it is how to deal, the modus operandi. Those who visit 5 years ago, you notice that on religious court, within every title, that you do not, you cannot consult with the judge. They used to consult him previously, but in the relation with the subjects, and so to consult it used to be. So this has a diminishing of the role of the religious court and shaping new relations. I refer to several issues related to this and review it within such interventions or invitations that require the religious courts to fall in line with its procedures and having to do with civil law. Inheritance was one aspect, a new concept, which is people who sort of leave religion, in a way, renegades, and to be related where you have people who are renegades, who sort of fall out of line from commonly established religions, and how this is viewed. The third thing in religious courts, that it wants to be part of the state modus operandi, not only the international humanitarian law one, but also they want to be part and parcel of the legal business. So the religious courts often reiterate that we want religious training. What is the court, the concept, how we deal with it, what are the procedures. This became a desire. They are looking forward to become part of such a system and cope with it. So organizing from 1997 until now, there has been building the religious court operandi that fits. We speak about early instance court, appeal court, and the high court, about a prosecution which falls in line with the Islamic Sharia, and that sort of feeds the existing practices. I want to see how such structures want to intervene with legal court, where you have a close relation between the civil and regular kind of legal system and the Sharia court, which creates a situation where such invitations want to renovate the control of the state and not applying human rights. We know that the essential idea, the focus, is to bring in the state in the process and reinvent such a space where it appears from a security point of view in the inheritance laws. It's not how much they share, but also you have to deal with the security apparatus and to take steps in order to facilitate your having access to the inheritance, although everything should be part of a procedural pattern in the courts, and seek such attempts. I want to start about renegades, or people who go astray from religion. It has to do with people belonging to the Ahmadi sect, that this is a kind of aberration from Islam, that these people are outlaws from proper Islamic traditions. I don't know whether this is right or wrong, but why did this movement or these issues surface? Although this existed since long time, and the legal courts deal with such a phenomena in different levels within hurdles related to marriage, in an attempt to get a divorce as one of the background, or to complicate the issues related to marriage. And religious courts dealt always in an essential way within such a framework of considering it outlaws. And the courts, they said that the person did not deviate from proper religious attitudes. The court used usually to take that the person is still a Muslim by witnessing the two kind of swearing. This is the basic requirement, that paying allegiance to God and His Prophet. But in 2010 a sort of dispute surfaces where you have the religious prosecution was formed first at the time, 2010. This religious prosecution has a new concept, which is the right of the Almighty in according to Islamic Sharia, where you have the public right, and you have within the Sharia court that deal with such issues. So this is the right of the Almighty that deals with a specific ethical background. It is not purely legal examination that the state should undertake to people within the concept of public order. And so this issue, which is part of the bickering of a family and between that takes a different meaning, so it becomes part of the religious obligation. Who is allowed, who is not allowed, what is the choreography of religion, and as such it provides a greater space for the state to interfere in specifying what is the essence of religion and what is kosher and what is not. So within this renegade system, that the court has to make sure on the facade that the person is certainly a Muslim. They don't take intentions. It doesn't get involved in is this actually believes earnestly in what he says. This is not the work of the courts. They deal with what is on the facade, not on the essence. Especially things that are associated with the right of the Almighty. The religious courts deal with what is visible, but the internal dynamics is not part of the responsibility of public order. It's not a public order, but this is referred to as, it is sort of an absurd kind of, it's not visible. So when there was a prosecution that has to check the thing, and you had the high courts to define what is the range of the court application, so it became a legal interpretation issue according to civil content, that it is not human rights which is sensible to the concept of being a renegade or the transformation as a result of being part of the public order. So this kind of sensibility, which is contrary to the idea of human rights, that human rights are not sensible to the concept of the state and the way it views things. It doesn't seek to intervene or abort or interfere, but it should be held under discipline. So human rights issues do not say we don't need as exceptionally issued court rulings by the state. What is relevant, what is not. And I think it's more important, pertinent to say that the authority legislates within the concept of human rights. I want to return to the personal status issues where you have the interference of the state that has to do with the contemporary laws within the Sharia courts and its tools. So the concept of renegade became part of the general thing that the religious courts would have been established recently and to be discussed. The issue, we have also a Supreme Court that needs also to check and issue its rulings. So the court came for the higher courts. And essentially, in Sharia courts there used to be one, and there are no exceptions. There are appeals now, and you have different levels of courts. And the Ahmadiyya sect, that as the court functions, try to investigate and to ask them to give the two oaths or witnessing to ask breaking the marriage for custodianship, that the mother or the father, about the children, that is, custodianship. So it went to the appeal court of appeal, that the early instance court has went, and we asked in order to break the marriage. The Supreme Court have to show their prowess, and they said, you are not applying the thing, you're not doing it kosher. I mean, there is no renegade law, but in the Hanafi sect, you do not have a clear text. So the Supreme Court has to show prowess, that it has its mandate. So it said it is not enough for the person to prove he is a Muslim. Or that he denies being the Ahmadi. So the Supreme Court here has moved the issue into a wider dimension. So there were legal procedures that gave a different concept of controlling a renegade. So ethically, they want to say that you are still a Muslim or out of this, without intention, without so on, to have a greater control, in other words. And you do not want to make sure that you are speaking the truth. The Sharia courts do not seek that. They don't go that far. They want, in order to maintain, in order to visibly have this, not to probe deeply, in other words. This model of intervention legally happens redundantly and have to do with issues related to inheritance, and the state should interfere. So we have to put, say, procedures in order to safeguard the rights of the women, for example. So, and I went and worked on religious courts on such issues, and I saw that this main claim that the religious courts, we should bring in the state within its range of concern. So let us start digging into it. And I knew that on issues of inheritance, for women it became difficulty to deal with inheritance. You need 2 to 3 months, according to your relationship with the security apparatus in order to get an inheritance thing. It used to happen in 1 or 2 days, the bureaucracy, but now the legal and administrative steps, where you have lands on sea and you need from preventive security a clearance, and they just file it until you bring somebody to interfere. You know, they look at the file in case you have favoritism, and the issue is to protect public interest and to prevent lands from being leaked out. The other issue is that you have to look, you have a court of appeal and the Supreme Court, and this will take time, red tape. So we should take, and you have in the inheritance control that you, so this takes, you know, a long while until it goes from one court to appeal and then to Supreme, and if you do not have people who will help in moving, maybe it could take 6 months to take a heritage index. In the Sharia court it used to be in 1 day, and building its relationships with the employees and where there is confidence until you get it, that it requires within the modern legal framework. And I would like to conclude with the issue to what degree such interventions basic that we request by human rights concepts, it takes into consideration, it's a sensitive issue having to do with the regular court procedures that tries to enter into the actual margin of Sharia courts and what it does on the ground. I want to give another concept. In its discourse of a certain issue within a certain context having to do with the religious courts.
Thank you. According to the program, we have only 17 minutes, but we can take 5 minutes away from the break. But let us start with questions or comments. Please introduce yourselves before you do the thing. Jad, question to Dr. Reem. You were saying that the Sharia courts are part of this system. Why? Should be part of this system. Why is that? Why should Sharia judges be a part of that system? Question to Mrs. Marina. What do you mean by the non-intervention of international law in states, even though it governed the relation between the states? Second question, you were saying that different laws were passed with regard to racism. Who or what was the body that passed the laws against racism? You said that there was the passage of laws about 10 years after the 1948 declaration. Which parties passed those laws and what? Yes, laws against racism. Okay, so question to Mr. Raphael. Palestinians, when you said Palestinians should recognize the rights of Israelis, what did you mean exactly? Could you please explain?
نحاول ناخذ بس عشان اوضح نحاول ناخذ بعض الاسئله النهائيه منها بعدين باقي اوكي تفضل.
All right, I just had a question for Marina. I was wondering if, all of you, thank you for wonderful presentations. I really learned a lot from this panel. Marina in particular, I was wondering, it was a great talk and I really agree with everything you said, but have you given any thought to why there is this distinction between the trend in the Inter-American Court and the European Court? And whether that might be tied in some ways to the settler colonial experience in the Americas and the fact that it is a relatively new migration and what has happened to the indigenous peoples.
To Rina. Mrs. Marina, you said that Europe tried to enhance European values all over the world, to spread and globalize them. And that they constantly called for human rights and so on. And you also mentioned that the European states sometimes abused and did violations in several countries. This could be correct, but except in the case of Palestine. Because we see double standards in the case of Palestine, double standards with regard to Palestinian human rights. What do you think about that? What we saw double standards, especially during the Cold War, when the Europeans were kind of were promoting the Eastern Bloc people to run away to Western countries. Human rights was being abused in order to stand against the Eastern Bloc countries. That could be one of the best examples on how to continue the Cold War. They didn't really care about human rights. It was more about politics. Now, the support of dictatorships all over the world is another example on double standards by the West. For example, that there are many countries, dictator countries, which do not respect human rights. You still do arms deals with them by $100 billion, like with the UK. The UK claims that it cares about human rights. How can it go and close $11 billion deals with dictator countries that violate human rights? So you see double standards all over. It seems like human rights are only for European residents. State of Israel is another example. Many countries consider that Israel is a country that respects human rights, but in reality they are abusing human rights on a day-to-day basis. From the Jordan River to the Mediterranean, from the north to the south, we see oppression, violations, and even stealing people's lands. So how do you see this? Thank you. Okay, let's move to the other side on the left from us. Okay, since I have the microphone already, I will ask question to Mrs. Reem. You were talking about the absence of the Sharia courts. Okay, I'd like to ask a question. I know that there are other issues that are currently being dealt with by the Sharia courts. What are they? For example, divorce and so on. What do you see the role of the Sharia courts in this respect? Two, we expect that the Sharia courts would take into consideration human rights. What's your view on that? Is there any specific role or party that specifies and clarifies the role of Sharia and religious courts? How should the religious courts act under the human rights considerations?
في سؤال ثاني؟
Hello. Thank you. I have a question for very interesting, the intervention, but I was missing. I thought that to produce possibilities of real change in regarding women's rights, and I think we should pay attention and identify dynamics, historical dynamics that we have witnessed in Palestine, especially since the inception of the PA. And the first one, I would say that to revise your assumptions that we are a nation in transition to statehood and democracy, and honestly, what I see is exactly the opposite. We are in transition, it seems, to a non-state which has the shape of a dictatorship to me. So first, and I think that has a lot to do with the possibilities of change, constitutional change and new political dynamics. But also there is an element there very important, which is this whole PA, not only PA, PLO, PA trope that we need to fight first for liberation, and then we will take care of the social things, included women's rights and etc. And I think the third thing is that we should also pay attention to the, I think, important work that women movements have, and I think has still in Palestinian politics, but especially at the beginning of the Oslo Agreement, and I'm talking about organizations like WICLAG, the Women Technical Committee, people who were involved in these issues and could produce good results. Thank you.
Thank you. Sandra?
شكرا للمداخلة. I have a question for Ralph, mainly because some people in the audience didn't attend your talk, and I want you to reflect further on a certain point for their benefit. So, but it's a genuine question. The various sites of international law that you've investigated and shown how they enforce the logic of statehood on both the PLO, but also the logic of recognizing the colonizer's state. Are there other sites in international law that do not force this logic, or is it inherent to any attempt to join the international community, or to join, to be part of that international family of nations, and to either directly or by taking part in its various sites? So, can you see any other site in international law for a colonized population that does not force that logic of statehood? And what is it, if there is? Thanks.
A comment to Mr. Ralph. I only saw a part of your lecture. You were saying that if someone is occupying the land of someone else, it seems like it is in charge of the affairs. I think this law doesn't apply to Israel, because Israel in itself is not legitimate, is an illegitimate entity which took the land forcibly and kicked the people. Israel in itself is illegitimate. So how can it be considered legitimate globally? And then you were talking about the right of return law. This law is quite fragile. Yes. There should be a law which calls for the forcible return of people, whether Israel wanted it or not just a right of return law. And then there are other, so this law is quite fragile about right of return. It seems like it is a suggestion. No, there should be the compulsory comeback or return of people. Israel must understand that they forcibly took the land, and Israel is a country that was illegally established on the account of the other people. Okay. Good morning. A question to Mrs. Marina. Do you think that the security consideration can be considered legitimate to violate the rights of refugees for the sake of security and the state? Question to Mr. Ralph, with regard to the sovereignty or the sovereignty of the state. In the case of Palestine, it seems like the sovereign parties here are Israel and the PA, but it could be also great countries like the powers or like the US or UN. And a comment to Ms. Sana. Israel could be one of the very few countries which do not have a constitution. And during the constitutional meeting with Mahmoud Abbas the other day, he said that one of the requirements of the UN to recognize us as a state is to have a constitution. But Israel does not even have a constitution, and it is recognized by the UN. Also, the participation of women is not there. It seems like the constitution has become a politicized thing more than anything else. So my question in particular is as follows. Sana, if we have a two-state solution, do you think that the constitution would really help the Palestinians who are living under the or would live under the Zionist entity? Do you think it would be beneficial? And thank you. Okay, let us start with answering these questions. 2.5 minutes for each. I know the time is limited, but let us try to stick to the time.
Thank you for the questions. For your question about the question if the declaration and the human rights have a colonial and European reality, I'm according with you. And the Galin, her name is Jorge Rodrigo Bandeira Galindo, is a professor, is a Brazilian professor. He said that there was, despite the emancipatory potential of human rights, the language of these rights has been manipulated through of the hegemonic powers. I'm according to you. And for we grant the human rights and necessary to be aware of the oppression potential of the universality of human rights. For me, it's necessary to make analysis of the regional dialogue of the human rights to be guaranteed the really human rights, and not European or I don't know, hegemonical power or of hegemonical language. About the question if relate the inter-American system, I'm a big fan of the inter-American system. Because the inter-American system, for me, it's same different of the European system. I understand the modernity and the construction of the human rights in the Americas starts with the discovery of the American, according to Aníbal Quijano and Henrique Dussel, Argentine professors. In this sense, modernity brought with the colonial a hierarchical partner of powers and chronology to maintain the domination of the people of the global south, and they are at the ideological discourse and intersubjective levels. In this sense, the Inter-American Court of Human Rights considered the requirement of equality and non-discrimination to alteration the conception of hegemonic and universal rights. In this sense, the Inter-American Court recognized like the non-refoulement, like a just causes, and the prosecutors like a just causes, the indigenous people's rights like a just causes, and the European Court of Human Rights. This is never possible. And for your question, if I understand the change of the declaration, the past, the comprehension of the human rights, is this? Okay. For me, this change is never. This change don't. Wait a minute. This change. This change has not happened because everything and everybody work the human rights discourse about Europe and the United States discourse is fundamental of intervention or discourse of the study of human rights. Me and you possible study human rights about the prespost of Europe and America, United States professors, books, and everything. And one that I remember is your question. I don't believe the last question. Yes, your.
Did you get the question?
No.
Oh, I didn't.
I'm sorry.
Intervention of international law.
International law. I'm sorry? The international law?
International law between states.
Yes. The utilization of the security, like a legitimate the intervention or international law. Well, in the European system of human rights, United Kingdom every time utilize the security for fundamental tortures, violations of human rights. And for me, it's not possible. Besides the security for violations of human rights.
Thank you. Sana?
Emilio, thank you. Thank you for your question. I think I'm going to answer you in English, so I can try to answer the question. So you asked me to revise, if I understood correctly, you asked me to revise what I think of the double transition. I had to think a lot about the double transition, really. And the reason why I'm saying that Palestine is facing double transition, a transition towards democracy and statehood, because most of the debate sometimes is about, are we in the route or the right path to democracy, or are we on the right path to statehood? So when I say that it's a transition, it doesn't mean that it's fulfilled. It's in the process, which I really hope to be in that path. And this is why we're talking about civil society intervention. We're talking about academics trying to put an input. So what I mean by transition is that it's, in progress. So we're not there yet. Your point that we are maybe in a dictatorship or there is like restrictions, I totally agree in the current stage. But when what my presentation was about the hopes or the aspiration, what we really want to have. This is why I did not focus on a specific country. I gave what the theory says or what we should be doing, or by looking at other examples. So if I'm looking at the current situation, then you're absolutely right. But the whole point of this presentation was to look at the future, or to give hopes, or to give examples. You're right in the point that, yes, there should be a focus on the basic rights, the social rights, before I talk about the implementation of the Constitution. But unfortunately, and experience shows, that even the attempts to write a new Constitution in 2016 was lacking, because the judiciary was not, the judiciary has major issues. The people that were selected to draft the Constitution were mainly males. So basically before trying to look at the social rights, what I meant is that let's try to fix certain things. Even civil society, there was a question about civil society. Even when civil society interferes or trying to write the constitution, I had like many discussions with them. They were not even talking about engendering the constitution. They want to add like certain articles. They wanted to talk about CEDAW. They wanted to talk in general. They didn't want to have the tools to work on the constitution. So you're right, but this is why even in my the beginning of my presentation, I talked about why women were overlooked. And you're right. This is why also I mentioned the preamble. Constitutions should mention in their preambles the struggle, the historical struggle, the role of the Palestinian women if we're looking at the future constitution. Because even the Palestinian women, they were always part of the Palestinian struggle. But whenever there is like a discussion about anything political, they are excluded. You're right in the example you gave, even when also agreement was signed, even in the PLO itself, how many women are represented in the PLO? So I think your questions were referring to a problem that we're facing, and my presentation was giving a bright picture or what we should look forward. I don't know if I answered. السؤال الثاني بس انا اختصرت من البرزنتيشن تبعي عشان اعرف اجاوب.
المشكله ما فيش وقت.
اوكي بس خليني اجاوب. اوكي بس خليني اجاوب سؤال.
Let me answer the second question or the third question. Countries do not have to have a written constitution. Even Israel has basic laws. They have basic laws even though they do not have a constitution. That is also fine. If you have basic laws, that actually governs and regulates the country in the best way. So in my presentation, when I was talking about how the basic law was written, you noted that as the president said, one of the main basics of recognizing us is the Palestinian Constitution. I personally think that we need to have a constitution and a basic law, because if we didn't have that, then we would have much more, or if we don't have that, we would have much more problems. If there has not been a basic law in Palestine, more problems would have happened on the Palestinian level. I think that the constitution is like the birth certificate of countries. Therefore, laws should be written well in order to regulate and govern and also preserve the rights of people. As for the last question, with regard to this, if there is a two-state solution, would the Palestinian Constitution include the Palestinians of 1948? I would say no to that question, because there is territorial jurisdiction, and the Palestinians of 1948 would probably be under Israeli law in that case. All constitutions in the world are limited to a geographic boundary. So if there is a two-state solution, I do not think that at any time it would include the Palestinians of 1948. And thank you. Yeah, you can talk during the break. Mr. Ralph?
The third question, all the questions with the three were linked in the sense that, is this on? No. Can you hear me? So the concern that to place the legitimacy of Israel into question, and indeed what I'm suggesting is that to have recourse to these international mechanisms of enforcing international human rights law necessarily assumes Israel's statehood, since the mechanisms are exclusively open to states, and the obligations that applied by them are obligations of states. So to bring a complaint against Israel to one of these institutions is to presuppose Israel's statehood, and therefore implicitly is a recognition of Israel's statehood. So, Samira, are there other sites in international law that don't, as I've just explained, these sites do force the logic of statehood? Were the world different? And this is the problem. And it is the nature of international law itself that is not specific to human rights treaties or the United Nations. This is the international legal system, which is based on an assumption about the ordering of human relations in the world according to the division of the world into sovereign states. This is very much cold comfort, given that that's the main answer. But then, how states are defined is itself a matter that is open to contest. And so what the state is, so within the logic of statehood, there are possibilities for contest there, and what the state covers and who its population and its territory, for sure. And in a longer version of this paper, I will explore how these different international legal instruments sometimes attempt to define statehood for the purposes of the instrument in a sui generis way that may be somehow different from how it's defined in other contexts. And that is playing out actually in how this question of Palestinian statehood is being decided by, for example, the prosecutor of the International Criminal Court will be addressed if this case brought against the US ends up going before the ICJ. That court will have to say, does the diplomatic relations treaty somehow have a definition of statehood that's somehow sui generis, and what would that be? So there are ways in there to potentially to making different disruptive arguments. Of course, unlike human rights law, international criminal law is about the obligations of individuals, not states, and therefore to make a claim of utilizing the jurisdiction of the International Criminal Court does not require an affirmation or an implicit recognition of Israel as a state, unlike bringing a claim under a human rights treaty, which is then a claim about the state's liability, not individual liability. International criminal law is only about individual liability without prejudice to the status of the entity in whose name that individual acted. However, it still requires a system of reinforcing the logic of statehood, because the jurisdiction of the ICC is only triggered if Palestine is itself constitutes itself as a state, and on that basis ratifies the Rome Statute, which then in turn enables the prosecutor to consider the situation in Palestinian territory on the basis that that is the territory of a state that is a party to the statute. So the logic of statehood is still actually required, and that feeds into what I was suggesting more broadly, that these instruments that claim to be about individuals and individual rights, and somehow then beyond statehood, are actually in many ways operating entirely within and reinforcing the logic of statehood and state sovereignty.
Just quickly to answer the comments with regard to the Sharia courts and how they should be. Well, there have been discussions about the roles of judges and what they will do, and so on and so forth. There has been also a conflict, and such conflicts, such as in 2002 and 2004, led to the resigning of several Sharia court judges. There is a disagreement with regard to the transformation and so on in these Sharia religious courts. Also, today we see that the legal discourse is the one which is prevalent. What I am saying is the opposite of what Sana is saying. That I am looking at the different angle and how the state would come and tackle the issue of the courts. So in the international conventions give the states the sovereignty to and the authority to tackle such issues, such as the general order and security and what have you. So I do not think that what you said is an issue of disagreement. We actually, I agree with what you are saying. So what I think is that new legal models must be introduced in order to make our legal court system more effective and more prevalent. We had about 15 minutes delay, but now we will take 10 minutes of coffee break. 10 minutes, and then we move to session 2 with Hala and then the speakers. Thank you very much for the speakers of session 3.